I did just send another email to Craig, just making sure he's got this Zoom meeting, and I would expect him to be on shortly.
Okay, and I just posted us, we are streaming live on YouTube.
Hey, Craig, I think we've got everybody um, that's available to appropriately to make comments during this, and then we're also streaming it on YouTube for those that want to watch it. But I think we've got everybody here now that would make comments. And I don't know if you're saying anything, Craig, you're muted, so if you're trying to say something, you're muted.
Sorry about that. Can you hear me now?
Yes, and nothing to be sorry about. It happens all the time. You think after COVID, we would just have that instinct, but it happens all the time.
Okay. So I'm trying to access this meeting on my computer. I was having some difficulty, so I went ahead and signed in on my phone. Let me continue to try a couple of simple steps here to see if I can connect with my computer.
I don't know if this is helpful to you, but sometimes, for whatever reason, it's easier if you connect from your browser instead of going through the actual Zoom. That's how I had to do it to access today, just so you know.
So it's my email connection. There's no issue with Zoom. That's the way to easily get the link I received to connect to the meeting on the computer. So looks like it's working okay. Let me just go ahead and finish the process. I appreciate being sent the link a couple of times, especially most recently by Andrew.
It's amazing how many times I hop on Zoom and then Zoom decides to upload and update the software and everything like that. And it's like 10-minute process to get that done.
Sure. All right, I think I can do this. So rather than blast feedback in your ears, I'll turn off the phone briefly. Right, that
Right,
appears to have worked.
Sorry, quick procedural question. Do I need to do minutes for this meeting? I'll do them, and then if I need to post them, because I didn't post an agenda, so.
Yeah, I think you can, or just even if you're recording it, transcript or whatever, I don't know that you have to type something up unless there's a question about it, but as long as we're recording it, that it could be watched later, I think you're good.
Okay, and almost got this.
Your phone's still connected.
Well, I
Trying
tried
to
to cancel
cancel
the phone connection and I can't seem to.
You're good, you're muted, so you're okay. On your phone's muted, so you're okay.
So you can't hear feedback?
Not with your phone muted, so we're all
Okay.
okay now.
Well, again, my apologies for the confusion. So I'll go ahead and start the meeting at this point. Today is Thursday, the 28th of August, 2025. My name is Craig Call. I'm the Land Use Hearing Officer for Grand County. This meeting today involves a sign variance request for a property located at Crescent Junction in Grand County. Just a couple of things to explain before I start. The job of the hearing officer, of course, is to hear the facts, establish facts, and apply the law to determine the outcome of an application. In this case, the requirements to obtain a variance are provided for in the Utah Code, which is referenced by the Grand County Code. I know nothing about the case except what I've read in the documents that have been provided to me. I'm assuming that everyone involved also received all those documents. To make sure that the county staff report was provided, I received it in an email directed only at me, so I forwarded it to the other people that had received other emails related to the hearing this morning. I also want to make a disclosure. It doesn't involve a conflict of interest, but it colors my background experience with this particular case in a way that probably should be disclosed. I come from a family with long experience in the oil industry. For 9 years, I served as the CEO of a subsidiary of Flying J Corporation and managed a group of gas stations, convenience stores, and truck stops. After that period, for 3 years, I served as the national community liaison for Flying J Corporation. One of my jobs in that position was getting variances for signs, where I represented Flying J before appeal authorities. I don't remember exactly how many involved signs, but I worked with about 30 different locations in 20 states. So unfortunately, I had to reveal my checkered past. I have no interest whatsoever in any gasoline facility or in Flying J or in the Maverick chain of gas stations, which other members of my family now own. I don't have any role whatsoever in those. So I don't consider that to be a conflict of interest in this case. But if you want to talk about gas stations and signs, I know a little bit about that. So any questions about that? Concerns? All right. By the way, I serve as land use hearing officer for some 15 different jurisdictions in Utah. I've been doing this for about 15 years. And this, it's not something that is new to me. Just wanted to explain that. I am a member of the Utah Bar and have been a land use attorney for some time. So let's start by making sure we know who's involved and what the who you represent, just for the record, to make sure we have it in the recording, which is part of the record of this decision. So Andrew, would you like to introduce yourself, and then we'll have the others involved?
Yes, great. Thank you so much, Greg. This is Andrew Jackson. I am a certified city planner and have been for many years. I am now, after I retired from my original occupation, I am working for Horrocks Engineering as a planning consultant, and I have a contract to assist with planning issues and that with Grand County. So I'm functioning under as a Horrocks employee under contract to Grand County.
Thank you. I'm still having some difficulty with feedback here. So I'm going to turn off my phone entirely, shut it down. Well, this device is smarter than me. I'm going to take it to another room. I'll be right back.
This is
okay. That should work much better. I could hardly hear you through my phone.
Oh,
so I'm muted.
Okay, I don't know if this is part of it with the disclosures and things like that, but over my 35-year career, I've worked exclusively with municipalities and counties, etc. I've not worked for developers on any projects.
Okay, thank you. And what's your position with the county now, Andrew?
I'm a planning consultant through a contract with Horrocks. So I'm a Horrocks employee with a planning contract with Grand County.
Okay. I would also like anyone else who'd like to speak. That means basically the applicant and the county staff, no one else, to also state their name for the record to make sure I know how to spell it in particular.
My name is Kristen Hoffine. I am the interim planning and zoning director, administrator for the Grand County. Hoffine, H-O-F, as in Frank, H-I-N-E. Kristen, C-R-I-S-T-I-N.
Thank you.
My name is Sean Yates, S-E-A-N-Y-E-A-T-E-S. And I am a Grand County employee as the county engineer.
Thank you.
I'm Cody McKinney. I am the Grand County Road and Bridge Assistant Supervisor.
One more time on your name, sir.
Cody McKinney, C-O-D-Y M-C-K-I-N-N-E-Y. And I'm the Assistant Supervisor for the Grand County Road and Bridge.
Thank you.
I'm Michael Everett. I'm with Texas Republic Signs. I am the permit manager for Texas Republic Signs.
Thank
I
you.
think I'm last. My name's Dan Stenta. I also am an employee of Horrocks as an engineering consultant. I was, at the time that this project was initially submitted, the site plan and all that, I was actually a county staff member and have some background with this project as a staff member prior to my departure from the county in March.
Thank you, Dan. Could you spell your last name for me?
Stenta.
Great, thank you.
Let's ask Michael, I've been emailing back and forth with Brad Everett. Are you the same person or a different person?
Same person.
Thank you.
My middle name is Brad.
Thank you. I just want clarification. Thank you.
Thank you for that. All right. Well, basically, the burden here is on the applicant. So, I mean, I'm certainly not locked into this, but Michael, if you want to go ahead and start the conversation or willing to, if you'd prefer to have Andrew explain where we're at and what the question is, that would be fine too.
Yeah, can we start with Andrew?
Great, that'd be fine. So Andrew, for the record, just kind of explain where we're at. You certainly don't need to repeat things that are in the documents that you might want to highlight anything, or you also can explain the county's point of view related to this application.
Yes, and I think Dan may have some background in or Chrissy with the previous application on this that brought it to a sign variance. The variance is for both the pole sign and the LED displays that are going to be proposed on the pole sign. Of course, you know all the requirements with the variance process, etc. I just wanted to give a little bit of so just identifying a couple things is we know there are a couple signs that do not comply with the current zoning sign requirements. And we've looked at aerial photography back to what we have as the latest, which is our earliest, which is 2006. And those signs were in place at that time. We don't know when those permits were issued, but we're assuming that they're possibly pre-existing non-conforming or non-complying. I think it's a non-conforming signs. But there has been changes in the sign ordinance prior to this application being submitted. And as staff, we just recommended that on variances, we want to have the applicant either comply with the code or seek to modify the code so that then their structure would be in compliance, because we put effort into the zoning ordinance and we want to make sure that we're not doing a zoning text change by variance. However, if this variance is granted by 9.13.6 of the Grand County Land Use Code, it allows the staff or legislative officials to make recommendations on conditions that would help the sign to not necessarily comply with code, but make it more acceptable. And those are listed in the staff.
Thank you. Mr. Everett, do you want to respond at this point? Was there another person from the staff who wanted to comment? Let's go ahead, Mr. Everett.
I think you've muted yourself because you're unmuted before.
Oh, there we go. See if that stays. Thank y'all for having me. What I am requesting here is for a 65-foot pole sign to be installed With an LED, the LEDs are stagnant. They will not change. They will not flash. They will not flicker. They are changed once a time, one time a day, or not even the day. It may go into 24 hours whenever the prices change. And they'll be changed by remote. So it'll be an instant change. It will not flash when that's done. I do want to say that the LEDs inside the cabinet are inside the top cabinet are hidden. They're behind a face. They're not going to, as well as they're not going to glow or any, or you're not going to see those LEDs in those as they're shielded by that face, and the green cuts down on the amount of light that is coming out of that cabinet. The reason for the 65-foot request is we have a topographic depression in that piece of property, and it's pretty significant off of Interstate 70. And the bypass will block a 24-foot sign, as well as the price. As we all know, price drives whether they pull into your station or not. And that is a determining factor in getting a big enough sign to be able to read that legibly and tall enough so that you can see it. We are aware that there is another Exxon station down the road whenever it was put in. We just want to be afforded the same rights as that Exxon property owner. We're not asking for 100-foot tall, which my client usually does ask for. We just want to be seen with the minimal amount of relief necessary for this project or for this station. I'm not sure if let me just say this, it's in the back of the property. So from one distance that we have from the exit, it's quite a bit of ways. I mean, it's like half a mile away from there, so it's going to be very difficult to see. And if we weren't afforded that 65-foot sign, then it just wouldn't be seen. It wouldn't even be worth putting in a sign at all. We don't have much signage on here. We can only have 2 signs, one over the front door and one over the rear door for wall signs. And those definitely will not be seen from any roadway. The safety of the truck drivers coming off that is very, very important to my client. And I do believe that the 65-foot sign would help in as far as the safety of the truck drivers and the people coming to get fuel for their passenger vehicles. I can stand for any questions that you might have.
Sure, I have a few. Can you hear me now?
Yes, sir.
Again, I'm sorry, I'm usually a whole lot better on this technical side. Looks like I did a great job of unmuting my phone connection rather than the video. So how high above the terrain of the property is the top of the overpass? So what the county is recommending is 20 feet, if in fact any variance is granted at all. County is saying it should only be for a variance to a height which would be 20 feet above the overpass. Understanding that there's no question of fact, it appears everyone agrees that a 24-foot sign would, if that was measured from the grade of the property where the facility is located, that would not be clearly visible from the interstate. But if the sign were 24 feet above the overpass or the highest point of the interstate there near the location, how high would that be from grade at the property? Do we know?
I'm approximating 25 foot to the guardrails.
So what you'd be at, it would be a 49-foot total sign height, if that's the case. Am I understanding that right?
Um, And that's approximation. Now, I'm not 100% sure what the actual height of that, but yes, sir, that would be correct. And if we did the math right.
Okay.
And I believe, I heard that we had the road and bridge with the city. Are they on? Maybe they could answer that better for us.
Yeah, sorry that we got unmuted. Yeah, as far as the interstate height from the property there, that's gonna be more of a state road. I'm not sure what the grade is gonna be on that either. 25 foot's probably a good approximation.
Thank you. Just taking a note.
Craig, this is Dan. I can pull up the site plan for this property, and I think the topo extended out to the interstate. I could have that for you shortly.
Well, it's fine. I'm just trying to decide how different that is from the 65-foot height, which is requested. It sounds like it's, 15 or 16 feet. If the county conditions were imposed and the variance was granted for the height, then it would be 15 or 16 feet lower than what the property owner is requesting. And that's close enough for me to understand what the issue is. So there are two options. One of them is for the property owner to go to the county commission and ask, obviously, any change in the land use code has to go through the planning commission and then to the county commission, where they would review the code and decide whether or not to allow this, signs of a different height in certain circumstances. The amendment could be tailored so it applied only to Crescent Junction. It could be, written in a way that would say where that different sign standards might apply to properties within a certain proximity of an interstate highway or something like that. But I'm kind of getting ahead of myself. The bottom line is the variance can only be granted when all 5 conditions which justify a variance are required. And I'm particularly trying to decide what the proper decision is according to the height. Before I go down that road too much, let me read you the code as it's written for the issue of the LED sign. I'm reading from the prohibited signs standards, which are found in section 6.5.4, prohibited signs. And under that section, item H says, under prohibited signs, signs employing flashing, intermittent, or moving lights, such as electronic or digital display technologies, LED, LCD, etc. My understanding of the code and the state law that applies is that ordinances are to be interpreted in accordance with the standards set down by the court. And we have had a recent amendment to the state code, the State Land Use Act, that has to do with the interpretation of ordinances. So let me express an impression and ask the parties here to respond. In my mind, this does not clearly prohibit LED signs. What it says is it prohibits flashing, intermittent, or moving lights signs. But if I understand it correctly, every LED sign or LCD sign is not a flashing, intermittent, or moving sign. So in line with the provisions provided for in state code and the legal precedent set by the Utah Supreme Court, ordinances are to be interpreted in favor of the use of property. And where on its face an ordinance doesn't clearly prohibit the use of property, then that use must be allowed. So it doesn't appear to me this clearly prohibits LED signs. It simply prohibits their being employed to flash, intermittently change, or move. Andrew, would you like to respond to that and help me?
I concur with what you stated. In my review of it as well, it looks like it's the flashing and the movement, those type of things. And that's why we've got in there that there's, I think it's item 3 under staff recommendation, that if it goes in place, that it would just be like Mr. Everett described, that the prices would change on a daily basis when the prices did change, that they would show up there. But yeah, I concur with your reading of that of the document.
Okay. Well, the application specifically asks for an exception to an ordinance which prohibits LED signs. And so it appears we agree that the ordinance doesn't prohibit LED signs. And it does prohibit flashing, intermittent, or moving lights on a sign. So that's already in the code. Does that sound correct to you, Mr. Everett, that if an LED sign is allowed, it can't be flashing, intermittent, or moving lights?
Yes, sir. I totally agree with the findings that staff has recommended. I just had conversations previously with another employee of, and he stated that they were not allowed. And I spoke to this, that they did not flash, but he was adamant about it, that they were not allowed. So I didn't push it any further and decided we'd put it into this variance just to cover all my bases. And if we could get back to the height, I want to explain one thing as to why we decided 65 foot, because I
Well,
didn't.
just a second. Let me wrap
Okay.
up the discussion. So I hereby insert my opinion consistent with the Utah case law precedent to that of the staff. The LED signs are in fact allowed under this ordinance, so long as they comply with the other provisions of the ordinance. So that will resolve one of the questions that was asked, and I just wanted to put a bow on that issue. Now, please go ahead and discuss the height.
Now, if I'm allowed the 24 foot, then we're allowed the 24 foot beyond what the roadway allows. That would give us, I think our math was 49 feet. The signage at 49 feet would still be blocked. That would just give us the even amount of being exactly with the top of that roadway. I'm asking, there's 14 foot of signage, so that's why the extra up to 65 feet or 64 feet would even be fine, as long as we can get that signage up above that bridge.
Oh, I'm sorry, the county is suggesting that if the variance is granted, you should be able to have the top of the sign at 24 feet above the bridge. You're saying the sign is 14 feet tall? I thought I looked
Well,
at
but between the two cabinets, the 8 foot plus the 24-inch gap, and then the 4'9", we're approximately 14 foot in height on the so that they're saying the top of the sign can be at.
Well, the top of the sign would be 24 feet above the freeway surface.
Okay. I'd have to do the math on that because
At its high point at the overpass. Is that true that the terrain there, maybe the county road department can help? I know I'm getting into the weeds pretty deep here. And you may want to take the time to make sure the response is correct. I'm not sure it all turns on this one issue. But is it true that the highest elevation on the freeway is probably at the point that it crosses the road heading to Moab?
no, are you asking me, sir?
I'm asking anyone who knows the answer.
I don't.
Any questions for Dan?
So this is Cody with County Road. I would say that yes, that's a that is a true fact, that the highest point is gonna be right there where it crosses 191. Dan, I think, is gonna, I don't know where he's at with those measurements on topography, but he may be able to clarify that.
Yeah, sorry, I looked, pulled up the site plan and their topo cuts off on the exit ramp that comes down, so it doesn't extend to the actual surface of the overpass, sorry.
Well, it's okay. We can craft if,
Right.
you know, the problem is,
Yes.
it sounds like I'm headed toward granting a variance and I'm not quite there yet. I'm just trying to decide whether there's some way to reach better understanding among both the county and the property owner as to the what the property owner might actually end up with if it goes to the county commission to review all these important policy questions and make a decision.
I think we can agree to the 24 foot above the adjacent roadway. At the top of the roadway as far as top of the bridge. I think that would be sufficient. I mean, that if that is in fact, that gives me, I'm up above the bridge. Gives me sufficient visibility. So it may be 65 here, but it's gonna depend on what my depth is of the topography of the land. It may be another 10 feet lower than my suggested 65 feet, so it still could be the overall height of 75 feet, depending on my topography and the height of that elevation of the overpass bridge.
Yes.
And just to
So
clarify, Greg,
we-
it would be the top of the sign at 24 feet above the crown or height of the, I don't know if it's guardrail, whatever you want to go with on there, but it would be the top of the sign that would have that 24 foot.
Yes.
correct. I think we would be able to be visible from that point.
Okay. All right. Well, let me go through this out loud as I ruminate. So, are there special circumstances related to this property? I think the answer is yes. It is on an interstate. It is lower than the roadway. In all other cases, except at Crescent Junction, the 24 feet grade of the property is most of the time relatively the same as the 25 as the grade of the road where a sign is directed. And the purpose of a sign typically is to provide information to those that are involved in moving up and down the roadway, whether in a car or a bicycle or as a pedestrian. So it seems like there are special circumstances. In terms of equal rights and property use, I guess one way one could look at that is how that then relates to the kind of use that commercial properties are placed at other places in the county. And the state code provides that it must involve a substantial property right. And as I've served in this position in Grand County for some time, if I remember correctly, I did in fact grant a sign variance some years ago and found that the ability of a commercial facility to communicate its use and function to the public was a significant property right. The next question is a hardship that's imposed on the property as a result of the property that isn't typical of others. That hardship in this case involves the commercial viability of the property. The hardship under state law cannot be purely economic. And that's a little tricky because every hardship has something to do with value. Obviously, a property that can't be used functionally is worth significantly less. So it always has an economic impact. But if the hardship is only associated with, for example, making a little more profit or getting a little more value for the property, then the question is, does that meet the hardship test? The applicant in this case has talked about not just the hardship that's imposed on the property owners, but on the public. One of those is a safety factor, where if a person driving an 18-wheeler decides to make a exit, they certainly should be able to do it in a manner that's safe and accessible. It's also important, I guess, to truckers to be able to understand what their choices are as they drive up and down the interstate. The interesting thing to me is the applicant has submitted and the county's discussed the signage a few, relatively close on the interstate at another facility, the 7-Eleven. And although the 7-Eleven logo towers above the facility, there's no price information on that sign. It appears that the price information actually is much closer to the ground, perhaps within the 24-foot limit at that facility. But then I don't know what impact that has on whether or not this property is treated similarly. There are a couple of other issues. One of them is the public welfare. I think the property owner has made some arguments about that and whether it's consistent with the general plan. My impression is what goes on far away from the general population center of Grand County may not be quite as critical to the purposes of the general plan as those that are located in the more populated area. I do acknowledge the county's recommendation that if variance is granted, that there be some provisions imposed as conditions which have to do with dark skies issues and extra light. So I know I'm rambling. I guess I'd like Mr. Everett to respond to my rambling a little on those issues, in particular, the hardships and how this involves a substantial property right.
Well, thank you for that. I do believe that the sign is a very important piece of information. It gives the people or the drivers, the operators of the big vehicles, clear, visible information about your product that you have to sell. Believe that the land itself is not just, as far as the topography goes, I'm not so sure that every other piece of property in town has the same hardship as they do, as this piece of property does. So then that makes this property special, or have that special circumstance that leads us to the variance request. The safety of the truck drivers and the patrons that will be filling the vehicles up at this place is also, in my opinion, is a hardship if they can't see the sign or get that valuable information that they do need. I can agree with you that the more populated places around the county, I know they have a rule that goes countywide, but is it really needed on these places that are not so populated out there? I'm not so sure that I answered your question that you might have, or you had, but
well, thank you. Would someone from the county or several from the county like to respond to my almost unintelligible stream of consciousness on this issue.
Just to touch on the dark skies, that is very important. And the request is to have some type of a device or blocking, whatever, for the trespass of light. So it's not like a total blockage of it, but just, and I have seen within Utah County and other areas where you go up on a ridge or whatever, and you can still see, I guess, the upward glare of signs. And so that's our request on that, is that if this is granted, that there be a blockage on the upward trespass of the light.
Mr. Everett, what are your thoughts on the dark sky restriction if the variance is improved? And this is something you just saw in the last hour and a half. I apologize. If you want more time to respond, we can continue the meeting. We can communicate by email. We can do whatever sounds fair to you, because this is basically provided to you.
No, I can appreciate that, and I do appreciate the dark skies, but and even if needed, we could put a dimmer on this. It's we're shielded, so the sign is not. It's a shielded green background that blocks the light. It just gives that color. It's not like it's a white. There's not very much white there, so the glare is cut down. Now, as for the LEDs, they also come with a dimmer built in. So if we go by the place and it looks like it's glaring or it's too bright, those can be turned down. This is something that we can address
So
and are willing to do so.
And this is, I'm too old to have ever been involved in this kind of conversation in relationship to dark sky ordinances before. So what the provision says is install a shield or similar device intended to block upward trespass of the light from the tall pole sign, and employ backlighting with LEDs only, no floodlights directed at the sign faces. So, Mr. Everett, do you have any concerns or questions about those particular words, or ways in which you would prefer that condition be modified to meet the county's concerns?
I don't think they need to be modified, because our LEDs are internal on the top sign, so that makes that statement. There's no LEDs on the outside of that cabinet, with the exception of that price sign. Now, there again, we can dim those down so that they are not bright. That can be done to meet whatever lighting ordinance is needed, and we have done it in the past. We've done it in Taos, New Mexico. We've done it in other places that do have this the same similar lighting restrictions.
I see. Okay. As far as the condition restricting LED sign lighting to steady operation or intermittent, that seems to be in the code, and this condition isn't inconsistent with what is already required of the sign. Mr. Everett, before I ask the county to respond to any of these conditions, would you like to respond to the county's suggestion that the owner post a reclamation bond to ensure removal of the sign if the business ceases operating?
Could that not just be put in as a stipulation? And why would we need a bond to do that if that's part of the condition of the approval? That if this place closes down, that y'all stipulate that the sign be removed. More than willing to do so.
Someone from the county like to respond to that response?
Yeah, I guess my concern is just that sometimes these facilities change ownerships, or even change from one brand of gasoline to another brand of gasoline, etc. Sometimes they may be independent of a chain, etc. And so if they go out of business, even though it's a condition of approval, if there's not a bond, which is only a percentage of the cost. But there's not a surety bond or something like that that assures removal. Lots of times that's not done, but if there is the bond, then it's more likely to get done. Chrissy, did you have a comment on that?
Not on that, but I do have one comment that I just kind of want to make sure that we get out there. One of the reasons that the county has such a strict sign ordinance is because, you know, generally this has been sort of discussed with the community, and they don't like they don't like billboards, they don't like the signs. And it doesn't, what we haven't talked about really is whether or not a sign has to be seen from a public roadway and whether or not that's a legal right. And that's kind of, it hasn't been touched on, and I just wanted to point that out.
So let me restate what I think you said and invite further comment, as I certainly intended to do. I mean, I'm not making a decision at this point as to whether or not to grant the variance. I mean, I may in 5 minutes, but not yet. But I did want to have this kind of conversation to determine how far apart we are on whether or not a variance is a good idea. So if I understand what you're saying, is that the provisions of the county ordinances were not created overnight. They were done through a deliberate and extended discussion with the public. And the county code as it's written represents a consensus by the county council at the time, or the county commission whenever the code was adopted. Looks like this was 2021, the most recent version. And therefore, the hearing officer should not lightly disregard the consensus that was created. And generally speaking, the opinion of the public is, in the Grand County residents, the people whose interests are being protected by the ordinance, that they don't like necessarily large and prominent signs, that it's simply not a preference in the local policy to encourage those kinds of commercial displays, which are not as favored by the public in Grand County as they might be in other places. Help me understand even more the point that's being made.
Yeah, I think also like there's no right to be seen. There's no right for an applicant for their business to be seen from a public roadway. And that's established in UDOT versus I mean, I could go into that a little bit. I don't think we need to, you're an attorney. But I do think that was important to state.
Thank you. So devil's advocate, and again, I'm just responding. Why would the county determine that a truck stop use is allowed in a zone without considering the idea that a truck stop can't survive if the potential customers can't see the facility?
A good point. I just felt like I needed to say that. People know me, they know that I at least let them know. I mean, I think that there's an argument for both sides of anything. I just think that as we were heading down one path, I just wanted to make sure that the people who have reached out and who worked very hard on our sign ordinances, were represented in this conversation a little bit. So
yes, thank you. Highly appropriate and appreciated.
Mm-hmm.
Well, I feel like I wish I had reviewed my previous opinion, which I have on my computer when it related to signs and I think this whole issue turns on whether or not having an appropriate sign for this particular use is a protected property interest. So tell me, just so that Mr. Everett's aware, what kind of timing would it take to amend the ordinance?
So to do a text amendment to the land use code is the way I envisioned that this would be corrected, so that we could compensate for, you know, things along 191, or sorry, I-70, because that would be the only place that I think this would really apply in the county. And it would have to go through the public hearing process, planning commission, county commission. Text amendments are done by applicants, so it would be on them to create that sort of, whatever they want it to look like, and then they would present it, it would go through the process. We currently don't have a planning and zoning administrator, or director. It's a 1.5 man show over here, so.
So
things
does
are-
it take weeks or months or years?
Well, we have it would go through 2 public hearings, and then the county commission doesn't vote at the first public hearing, they vote at the second. So they open up the public hearing, they don't discuss till the second, so it's at least a 6-week process. Depending on when meetings fall.
I think that 6 week would be the best case scenario.
Mm-hmm.
Everything submitted exactly on time to meet the schedules of when it has to be out, et cetera. So yeah, you're looking at 6 weeks on the best case scenario, and probably 60 days, 2 months on maybe an average. It's not a huge change to the code. But yeah, I think something like that, 6 weeks, 60 days, again, pushing things through as quickly as we can.
But I could be denied and be right back where I'm at.
That's right. There'd be no guarantee whatsoever. The county commission's legislative act to amend the code would be non-appealable in any practical means. We don't have a Utah case where the Supreme Court or the Court of Appeals has overturned the county's discretion on how much height to allow for a sign, even along interstate corridors.
Right. And I'm opening the facility on October 7th, so my time is of essence.
So the facility is under construction?
It is, yes, sir. It's October 7th, they open the doors.
Wow.
Maybe if I could, Craig, if you're okay.
Yes, go ahead.
So the application has been in our process or was accepted, the variance application, about 80 days ago, 82 days ago. We have had some shifting in staff, either retiring or quitting or whatever. Unfortunately, one of the people who was the original staff person who received this application is no longer with the county, and I'm not sure, maybe it was a month and a half ago that she left, and so we're trying to catch up on some of these things, as Chrissy stated, with the limited staff and trying to make sure that people have their due process. And so it's taken longer than what we would expect normally with a fully staffed staff and not having people leave. So we're trying to get that going.
Interesting. Okay, well, it seems to me what I need to do is go back and read my other opinion to make sure I'm consistent in my interpreting the Grand County ordinances. But before we wrap up this part of the process, I certainly want to give anyone the opportunity to make any other comments they'd like to make. I do fully expect to make a decision within a day or two. So by the end of business tomorrow, you should know exactly where I'm at. Any parting thoughts or comments?
I just want to say thank you. I appreciate it.
I'd like to say thank you as well. And in doing so, I do believe that we met every criteria needed for this variance, called out in the narrative that I wrote. And the unnecessary, I mean, the hardships are there, they do exist. And I do appreciate y'all taking the time Abigail's Day to hear this hearing.
Well, I certainly want to respond quickly. I understand from what Andrew has explained that this is an unusually long process that shouldn't have taken this long. So, other thoughts? If not, thank you very much for your time. It's now 1:00 p.m. and we'll conclude this hearing with the understanding that I will take the matter under advisement and issue a written decision. I may advise you of my conclusion before I provide the written decision, because I want to make sure it's crafted in a way that fully explains the position I may have come down to decide. Again, thank you. That should conclude our business today.
Thank you.
Thank you.
Thank you.